Hi there, I'm James Egan. I'm a DUI defense lawyer in Washington State. I've done over 2,000 DUI defenses. I've been a lawyer for 26 years. I've done about 50 jury trials, hundreds of motions hearings, hundreds of phone department of licensing hearings. And today I want to share on YouTube, not just TikTok, the video that describes what you should know if you're recently charged with a DUI or recently arrested, and what you can do, sort of the circumstance, where you're at, and where it can go from here, especially if you hire a good lawyer. So let's see if we can cover this. So what you should know, if I just had to summarize it with DUI, is that there are two procedures that are going on. If you've just been arrested in Washington State, first off, there's the civil or administrative procedure, and then there is, secondly, the criminal procedure. They are not connected to each other. A lot of people assume they are. They're not. It's not just one action against you. First, the Department of Licensing will move to suspend your license, and this is because they will say, based on the officer's representation to them, that you violated what's called the implied consent law. In Washington State, if you drive a motor vehicle, whether you have a license, whether you're from another state, whether you've never had a license, you impliedly consent. You consent by the implication of driving to provide a sample of your breath if you're lawfully suspected of being DUI by the officer, if you're pulled over properly and the officer says, hey, you're DUI. Then you provide a sample. If you do provide this breath test sample at the station and it's over 0.08, then you have violated the implied consent law, and the Department of Licensing, upon receipt of that fax police report from the officer, will move to suspend your license for 90 days. If, on the other hand, you're suspected of being DUI and you refuse to provide the sample, then you'll be losing your license arguably for a year. Now, all of this is contingent on whether you challenge it, etc. And that's where I'm going to tell you, challenge it, because it is not always by default. It certainly isn't if you challenge it. If you don't, then it will certainly go into suspension by default, and it will go into suspension by default 30 days after the incident. So what happens is, suppose you're arrested on December 1st. Then the officer sends in the Department of Licensing this packet of police report, on top of also sending it for criminal prosecution. But before sending it, the Department of Licensing says, whoa, you violated the implied consent law, and they will send you a notice that on December 31st, 30 days later, your license will be suspended for 90 days if you're over 0.08 and a year if you refuse to test. Now, you have 7 days from the incident date to challenge the suspension under current law. That means that by December 7th, you must send in notice to the Department of Licensing that you want to challenge it. You can do this online. I encourage people, if you do it online, make sure that the Department of Licensing actually charged your bank card, because I've seen people say, well, I thought I went through it, and they hit challenge and something came up and it said, okay, your challenge is pending or something. Or it says, for example, it says that your challenge isn't timely because it thinks that you haven't challenged it within 7 days. If that is the case, then I highly encourage you to mail the request. And when you go to the post office, mail it with a return receipt requested so that you know it's been received. So even if it's late by a day, the computer won't accept it online, but if you mail it, I can certainly get the notice of denial and usually can get it to be reopened based on some argument, so I can actually preserve the hearing. Now, what is the hearing about? The hearing is a phone hearing. You don't need to be present. You do not need to be present. If you have a good lawyer, then your lawyer waives your presence, and there are 4 issues at that hearing. Based on the police report that was submitted to the Department of Licensing, whether you're lawfully stopped, whether there are reasonable grounds to believe you were DUI, whether the implied consent warnings were read to you, and whether you then blew over 0.08 or refused. And that 4th question is determinative of whether you're going to lose your license, or whether it's 90 days on the line or a year of license suspension on the line. Now, something like 85% of those hearings are lost. Generally, my track record is more like 50-50. They are all supposed to be lost, but there are certain ways and tricks and methods to make it more likely that you're going to win. So if you hire my firm, then we go to town. But the key is you need to make immediate action to get that suspension challenged, because if you don't, you'll lose your license by default. Now, you might say, well, shit, I missed the boat, I cannot challenge the suspension. Then my advice to you is to get an ignition interlock license. You're actually allowed these days to drive during that entire time. So if it's 90 days or if it's a year, you can drive that entire time, but you would need in your car a blow and go device where you blow into the machine that is installed, and only if you do that and you have no alcohol in your system will the car drive, and you would be required for that entire window of time to drive with that device in your car. Now, that is not recommended because it costs money, it's onerous, sometimes it's mistaken. Certainly people have circumstances where they have carpools, or they're driving kids, or they're picking up their boss from work or something like that, and it would be evident that they've got a blow and go device. So I usually say challenge it. There are certain ways around it. If you are in that situation, you have to contact me and I can walk you through it if you hire us. Now, I said there are two procedures. There's the civil and the criminal. The civil is an immediate procedure. That happens automatically if you've provided a breath sample. Sometimes, in the case of a blood draw, it actually happens months later when the blood draw gets received. But if the breath test is done or refused, then the cop is trained and knows to send to the Department of Licensing the police report showing that you violated the implied consent law. It's implied consent, it's not express. You didn't sign anything, but just the fact that you're driving means that you're subject to these certain laws that could result in a suspension of your license. Now, the other side, the criminal, that is an entirely different ballgame. That is actually where there's more jeopardy, because of course with the Department of Licensing, if your license is suspended, you can drive with this device and so what? So it costs you money, it's a bit inconvenient, it doesn't result in any significant consequence to your liberty. The problem we have though is in the criminal case, that is where things can go hard. Now in the with the criminal case, there are two ways to prosecute somebody. One is to say that they're over 0.08 within 2 hours driving, 0.08% alcohol, as shown by the breath test at the station. Let's please not confuse the one at the side of the road. That is a toy. The one that the officer pulls out of his pocket after pulling you over, there's no obligation to provide a sample in that. You can refuse it. You can provide a sample over 0.08. It will not affect your driver's license, and it will not be told to a jury because it's effectively a toy. It is not scientifically sound enough to be presented to a jury. That's what the courts have held. However, the one at the station, the Draeger it's called, is very good in the sense that it will be relied upon by the scientific community, and it will provide 4 numbers. There are 2 numbers on the first sample and 2 numbers on the second sample. If all of those numbers are over 0.08, then the prosecutor has what's called a per se DUI charge available to them. They will charge you with driving a motor vehicle and within 2 hours having over 0.08% alcohol. Now that is the objective prosecution. But understand there are 2 methods of prosecution. There's objective and subjective. So the objective is numbers game, do the math, this person's over 0.08. The subjective is that somebody is driving a motor vehicle while their ability to drive is affected to an appreciable degree by alcohol. And these are the exact terms. A lot of people say, well, what does that mean? Well, you know, jury instructions are given to juries, and what they understand is that appreciably affected means that there is a significant and measurable impairment. Now, usually that's based upon observation. So the officer observed somebody get into a crash or saw the crash after it happened, or somebody was passed out in the roadway behind the wheel of their car, or something else. But it doesn't necessarily have to be the driving. It may also include the field tests. So field tests, walk and turn, one leg stand, horizontal gaze, nystagmus. Officers are looking for evidence of impairment. So they've already established that you're driving, and here if the officer's going to pull you over, they're going to ask you to do these field tests. Now, here's my quick advice. If you're in this situation, probably the best thing to do is ask for a lawyer. Don't do field tests, and provide the test at the station, because otherwise you're going to lose your license for a year. I can challenge that. Now, if you want this all to be fixed and cured, I'm very good at doing that. I've done it for 2,000 prior clients. Contact me. The call is free, 206-795-3292. I'd be happy to help you. Again, I'm James Egan. I am a very accomplished DUI defense lawyer, and my phone number for free consultation is 206-795-3292. I always offer payment plans. Call me. Thank you.